You got arrested, but you're not a criminal. And now you're stuck choosing between a conviction that ruins your record or a fight you're not sure you can win. What no one is telling you is that there's a third option that could make your case disappear entirely. No trial, no conviction, no permanent mark on your record. I'm Nano Knight. I'm a criminal defense attorney here in California, and I've helped clients walk away clean using this exact strategy. And in this video, I'll break down how conditional dismissals actually work, who qualifies, and why most prosecutors won't volunteer the option unless you know to ask. So you don't plead guilty to something you could have walked away from. Let's clear up the language first. Conditional dismissal isn't actually the official label that's used in a courtroom. The official word you'll hear is diversion, but the concept is exactly what it sounds like. Your case gets put on pause, you complete certain conditions, and if you finish, your case gets dismissed, meaning no conviction on your record. It's not magic, it's a structured second chance. And for the right person, it's the difference between I made a mistake and I have a record forever. And here's the part that frustrates people. Prosecutors are not in the business of advertising these types of off-ramps. If you're willing to plead to something today, that's easy. It clears their calendar, it improves their stats, and it closes your file. Diversion takes effort. It takes court monitoring, it takes paperwork, and it takes someone pushing for it. So most of the time, if you don't ask, if your lawyer doesn't ask, you'll never know it was even on the table. In California, most conditional dismissals fall into 3 lanes. The first lane is broad misdemeanor diversion. This is where a judge can pause a misdemeanor case and impose or order certain conditions and give you a path to a dismissal, even if the prosecutor isn't enthusiastic about it. It could be done over the prosecutor's objection. The second lane is offense-specific programs like drug diversion. Some charges have their own diversion track that's built into the law with specific rules and specific timelines. And the third lane is a special circumstance type of diversion, like mental health diversion, where treatment is the focus and the court has discretion to redirect the case. On top of that, there is a fourth version that happens in real life all the time through negotiation. A strong defense can sometimes get an informal agreement where you do something constructive, like restitution, counseling, community service, and the prosecutor agrees to dismiss if you follow through. Not every DA will do this, and not every case fits it. But it's absolutely a lane we explore when the facts support it. Now let's talk about the reality of eligibility. These options are most common when you're dealing with a nonviolent, low-level type of case, especially if it's a first offense or you have a clean record. Think situations where the damage could be fixed. A petty theft, for example, where restitution and a theft class make sense. A vandalism case where cleanup and community service fits. A minor drug case where treatment and education is what actually moves the needle and addresses the underlying problem. That's the mindset behind diversion. The court is looking for a safe way to resolve the case without branding you as a criminal. And yes, some charges are excluded and judges still have discretion. So this is never something you assume, it's something you analyze. What the court usually requires. If you're picturing a free pass, that's not what this is. Most conditional dismissals come with very standard kinds of requirements. You're typically going to see things like the court ordering you to complete a class, counseling, community service, restitution, staying arrest-free for a certain time period, and sometimes even submitting yourself to alcohol or drug testing. The point is proof. Proof that this was a one-time situation. Proof you took it seriously. Proof you're not going to come back. And when you do what the court ordered, that's when you earn that dismissal. Here's what this looks like in real life. Here's a clean example. Let's say someone gets caught shoplifting at a big store in San Jose. There's no violence, there's no threats. This is the person's first offense. A standard conviction route might be plead guilty, take probation, and live with the record. A conditional dismissal route might look like pay restitution, complete a theft awareness course, stay out of trouble for a set period of time, and then come back and get the case dismissed. Same mistake, completely different outcome. Another example. I had a client arrested for vandalism. It was his first offense. He was a good person, but made a bad decision. Instead of letting that become a permanent record, we pushed for a conditional dismissal structure. Repair the harm, do community service, and comply with the court order terms. The result wasn't a watered down conviction. It was a dismissal. And here's how this works in practice. First, you ask for it early, not after you've already negotiated yourself into a corner. Early, when the court still has options and the prosecutor still has flexibility. Second, you show the court why you're the right candidate, not with excuses, but with receipts. Work history, school, family responsibilities, counseling that you've already started, restitution that you've already paid, or classes that you have already completed and you have the certificates for it. When you walk in proactive, you stop looking like a defendant. You look like someone who has taken charge and who has rehabilitated, who is trying to show the court that they're not going to come back in the criminal justice system. You start looking like a person the court can trust. Third, you get the terms clean. If it's diversion, you want the conditions spelled out, deadlines clear, and the proof requirements obvious. Because the fastest way to lose a dismissal opportunity is confusing, not properly being able to comply with the terms, or missing and paperwork that the court ordered to produce as proof. Now let's talk about the mistakes that blow this up. Most people don't lose conditional dismissals because the prosecutor outsmarts them. They lose them because they get sloppy. They miss classes. They miss deadlines. They fail to turn in their proof, and they assume the court knows they finished, or they pick up a new arrest during the diversion period. Any one of those can flip the situation right back into a normal criminal case, meaning you're back to pleas, trials, and consequences, and potentially having a conviction on your record. So the rule is simple. If you get this opportunity, treat it like it's fragile, because it is. So now let's talk about what happens to your record. This is the question everyone actually cares about. If you complete diversion successfully, your case gets dismissed. And you can honestly say you were not convicted. But here's the nuance most people miss. Even when a case is dismissed, the arrest record can still exist in the background unless it's sealed or treated as a sealed arrest under the specific program. And there are also exceptions where certain government agencies can still see the sealed records or have access to it. And certain applications, like when you apply to become a police officer, this can trigger disclosure requirements. So the clean way to think about this is this. Diversion is step 1. Avoid the conviction. The record cleanup may be step 2. Address the arrest record if needed. That's exactly why you don't want to guess your way through this process. You want a strategy that covers both outcomes, the court outcome and the record outcome. Let's talk about when conditional dismissals are not the right tool. Now let's talk about when a conditional dismissal is not the right tool. I love conditional dismissals, but I'm not going to pretend they fit every case. If you've had a long history, if you've already had multiple second chances, if the charge is serious or excluded, or if there's a victim situation that changes the court's posture, diversion may not be available. And even when it's available, you still have to be a good candidate. The court has to believe you actually will do the work. So let's do a quick recap. A conditional dismissal is usually California diversion under another name. It's the third option most people never hear about. The case gets paused, you complete conditions, and you can earn a dismissal. No trial and no conviction. But prosecutors don't volunteer this. You have to know it exists. Ask for it early and build a plan that makes the judge comfortable granting you this diversion. And if you do get it, don't treat it casually, because one missed deadline can turn a clean dismissal into a permanent problem. Now, if your arrest involves something more serious, especially domestic violence, the rules change. The stakes rise, and the record cleanup gets a lot more complicated. In the next video, we're going to talk about how to erase your domestic violence arrest from your criminal record. I'll show you the legal steps that can help you clean up an arrest record and protect your future the right way. Click over to that video now, and don't plead guilty to something you could have fought smarter. I'll see you over there.